Assalamualaikum and hi. We are going to present the case review of YA DATO HAJI HUSAM bin Haji Musa versus Muhammad Faisal bin ROHBAN. First is facts of the case. The case was issued when a blog named ruangbicara.faisal.blogspot.com posted a malicious article entitled Husam dan Tamrin Balon Balat 15 juta. In response for that, the plaintiff, who is a well-known past politician, had commended a defamation suit against the blogger defendant. But then, the accusation was denied by the defendant, saying he was not the author of the article or even the blog owner. The High Court viewed the defamatory article and affirmed that the article was referred to the plaintiff. The court claimed that the plaintiff failed to present the evidence whether the defendant really was the owner of the blog or not. So, an appeal was filed. The plaintiff submitted some documentary evidences, but the High Court refused to reconsider even some of them are already marked. The case was closed as the plaintiff failed to prove the defendant is the one who created the scene by presenting the article on his blog. At that night, it has revealed that the defendant was the legitimate owner for the blog and also for the article.
Next, we go to the issues of the case. In this case, we have three issues. The first one is whether the defendant really owns the article and the blog. Next is did the both sides, the plaintiff and the defendant, have solid and legit proof to defend their stance. The last one is whether the order of trial judge are made correctly according to the law. Next, we go to the judgment of this case. The judgment is that there were errors committed by the trial judge in the earlier judgment along with the misdirection on the law, which has caused an unfair, procedural and perverse. The fact that the defendant lose and fail to grab the presumption leads to the Section 114A of Evidence Act 1950. Even worse, the defendant needs to refund RM50,000 to the plaintiff, but it will be remitted by the High Court for any assessment of damages. In YA DATO HAJI HUSAM bin Haji Musa versus Muhammad Faisal bin ROHBAN Ahmad, Court of Appeal Civil, Appeal Number D02-1859-08/2012, the defendant denied writing a defamatory post, and the High Court held that there was insufficient evidence to prove that. The Court of Appeal ruled that the learned High Court judge should have applied Section 114A and that the defendant in this case refused to refute Section 114A's presumptions. The Court of Appeal held that, in general, liability is attached before the elements of defamation are met and the defendant's defense would not survive mere denial, and that Section 114A will aid the plaintiff in forcing the defendant to release himself from the liability when it comes to cybercrime. So about the Section 114A of Evidence Act 1950, this section means anyone who have their own name, photograph or pseudonym published and issued without them being the owner, host, administrator, editor or sub-editor, or who have the custody to publish or republish the publication is presumed to have been published by the true owner of said name, photograph or pseudonym.
Lastly is for critical comment of the case. Despite the fact that the blogspot was clearly his, we believe that the defendant was genuinely at his fault and being manipulative. The article of Mohon Maaf kepada rakan-rakan blogger contains a connection to the blogger and his father, as well as the fact that the blogger's phone number in his profile is the same as the defendant's younger brother, which is Fakhrul Rohban, where the defendant was using. Due to the section of 114A's connection to the cybercrime, the plaintiff would be able to compel the defendant to exonerate himself from guilt because the defendant's defense was nothing but denial. It is considered ambushed in this case because it is using the forum to fulfill a hateful need for them to convey their frustration. Furthermore, we believe that the trial judge took his job for granted. He dismissed the law implied in this case, despite accepting the facts as valid and even admitting it and refusing to consider it solely because his dissatisfaction with the plaintiff's admissibility procedure. The judge's decision to consider the defendant's testimony and the bare, simple denial defense is utterly ridiculous.
That's all from us. Thank you.